Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andrus. Today, we're continuing our discussion of some of the due diligence issues that practices need to think about as they prepare potentially to sell, but otherwise are just getting their practice into good shape. We pick up where we're talking about some of the stark issues that come up when we're doing due diligence reviews with buyer's counsel. Another thing I want to talk about is Stark. So everybody's heard of the Stark laws, and depending on your practice and the services you're offering, it may or may not apply. But from the perspective of what's in the compliance plan and what buyer's counsel is looking for, one of the things I want to talk about is how an average practice that offers ancillary services, which could just be x-rays, labs, DME. I don't know, but there's obviously, for those of you that aren't familiar with Stark, Stark is a law that must involve Medicare patients, designated health services, and there's CPT codes online that are specific, but they generally involve categories of ancillary services, such as radiology services, um, you know, all kinds of imaging, physical therapy, um, you know, um,
Home health.
laboratory, etc. So if you're offering those, you may be covered, and most small practices are offering something like that. So when a physician is ordering tests within their own practice for these items, right, or sending patients somewhere to receive these tests and they have any kind of financial relationship with the place they're sending them, you automatically are going to be implicating Stark. And it's a huge law. We're not trying to cover it here. But if you think that you might be covered by Stark because you offer ancillary services to federal patients, one of the things I want people to think about, and I'm going to have Christina kind of explain this in a little more detail, is whether or not you've ever had your compensation arrangement with your doctors in your practice reviewed for compliance with Stark. So when a buyer is buying your practice is doing fabulous. The doctors are getting paid very competitive amounts, and it's a great practice to buy. But when they dive in to your compensation arrangements, what are they going to find? And this is something people often forget. So, Christina, give us a little background on how Stark impacts compensation arrangements.
So Stark doesn't essentially allow physicians to be rewarded for referrals for these designated health services that are payable by Medicare. So a really good example, and we've seen this before, is they practice has a CAT scan, okay, right, or an X-rays, and doctors refer Medicare patients to receive CTs, X-rays, and when that money comes in for the CT and the X-ray that was taken, the technical fee for that, that can't be credited directly to the doctor who ordered it. So, if Eric and I are both doctors and she orders 10 CTs and I order 12 CTs, so all the money for her 10 CTs, they credit to her. The money for the 12 CTs, they credit to me. That is not Stark compliant. You have to handle this DHS income that's Medicare payable in a very special way. And it's a way that's Stark compliant. And I gave an example that's a very basic example. It's kind of Stark 101, but there's a lot more detailed and a little bit more difficult Stark problems that happen with ancillary services and with compensation arrangements that need to be reviewed. And there can be some complex Stark problems where practices who know Stark and understand Stark and think they're complying with Stark aren't, because they didn't know some of the very, more detailed Stark rules. So that is a huge issue for due diligence when you have a buyer. Any knowledgeable buyer wants to make sure your compensation is Stark compliant. And we work with a lot of practices before that didn't have Stark compliant compensation. We had to work to sort of unwind that and fix that. Or maybe they were Stark compliant, but their policy on how they billed for things wasn't Stark compliant. They were doing it correctly, but the written word didn't match that. So we kind of found that in advance and made sure that the written word matched really what they were doing, which was compliant. So these are all things, again, that are important to look at before you're going to enter the buyer's market to sort of eliminate the need for the buyer to point it out to you that it's a problem. You already identified it and you fixed it moving forward.
And a couple of other things as doctors switch from full time to part time, or as your practice grows or shrinks, the number of doctors and how much they're working can affect whether or not you're start compliant, even using the same exact formula. So that's a real reason to continuously be talking with your lawyer and make sure that what you're doing is compliant. So this is a Stark law. And so one of the things I want, Christina, just you to speak to, let's say you fix it right before you do a deal, or you fix it when counsel points out that you've been doing it wrong. What are the repercussions of having violated Stark?
So they can ask for the money back. They could ask for damages in excess of asking for the money back. The referrals that were made incorrectly under Stark are essentially considered akin to false claims. So there are financial repercussions for sure. You don't go to jail for Stark violations, but you can go to jail for kickback violations if there's some criminal intent there.
Right.
So one of the things you want to do is if you do find there's a problem, there are reporting mechanisms that you're required to avail yourself of. Report to CMS, report to OIG if it's a kickback issue, but there's an actual reporting obligation, and making those reports generally is favorable to the government and will, in every case that we've helped clients made report, we've gotten sort of the minimum amount the government will take to settle it. So my experience is they generally review reporting favorably and will work with you to sort of minimize, what the fines and penalties might be, and work with you on repayment. But it's not just a matter of, okay, we had a problem, we're going to fix it moving forward. You need to deal with the problem you had before you fixed it, and a lot of times that is a reporting obligation to the government.
And by the way, even if the deal doesn't go through, you still have this duty to disclose. And this is something practices really struggle with. They're kind of like, well, if the government didn't know, why should I, bother? They'll never find out. And, obviously we always advise our clients that they should self-disclose and do what the government's looking for. Whether or not they all follow our direction is a completely different issue, right? But it's something that practices really struggle with. Now, once opposing counsel has found out about it, obviously the choice is sometimes out of their hands. Whether there's a deal or not, there are now other people who know what's going on.
And that's also why it's super important to make sure when before you get into heavy negotiations about a practice purchase sale, have an NDA in place, because you want to make sure that you have non-disclosure agreements with these other parties, because now 5 or 6 people on the other side know that you've been violating Stark for 6 years. We want to make sure that those people are not going to go run and proactively tell the government about that.
Right. Very, very important. All right. So the final issue that I want to talk about, and as I said, we could talk forever on the things that people are doing wrong, is HIPAA. So everybody is fairly familiar with HIPAA. They are aware that there's a requirement that a covered entity, which includes a practice, has a duty to keep information private, has a duty to sign business associate agreements with the companies that it does business with if it's going to be sharing patient information. And so that's just a really brief summary of HIPAA. Among the questions that counsel is going to ask is see a copy of the HIPAA compliance plan, ask whether there's been any audits, both from a technological standpoint as well as just from of the documents of the practice, whether the practice has logged any improper disclosures, whether the practice has gotten signed BAAs, whether the practice has done annual training, what type of training have they done. The questions related to HIPAA are probably the most detailed and expansive of all the different categories that we've talked about. And unfortunately, despite our best efforts to educate clients, most of our practices have done the bare minimum, if that. Would you agree?
Yeah, that's a fair statement.
So this is very concerning because there is a risk that the buyer then faces. In a recent transaction that we're working on, in addition to not having signed BAAs with everyone, it was also in an IT analysis that was done, software that our clients were using that they thought was very safe, actually was not HIPAA compliant. And so although it could be fixed going forward, we then face the issue of what has happened with all the information that's been shared in a non-HIPAA compliant manner, right? What is the cost to fix it? There had been no education of staff, no ongoing training, no documentation of training. They did almost everything wrong, and that's not an unusual circumstance, unfortunately, with small practices. So I guess, one of the questions is, what are the most basic recommendations? We don't want practices going out there and having to spend a fortune, then they don't need to. But what are the most basic recommendations that you think we should be making to practices who are listening to this, who are thinking maybe of selling, even if they're not thinking of selling, what to do to become HIPAA compliant?
Got to have a policies and procedures manual. Has to be functional, has to meet what the law requires, has to be followed, and your employees need to know about it. That's the first thing. HIPAA has been around a really, really long time. So you can't use an excuse now, well, we didn't know or we weren't sure. The government's not going to let that fly because it's been around super long now. People know enough about HIPAA to even know when to even use HIPAA incorrectly. I see memes all the time about, someone will say, well, I found out about this about my neighbor's health and I can't say anything because it's HIPAA. No, that's not HIPAA protected. But I mean, even just the general population knows about HIPAA. So you have to have a compliance plan. And the one that you did, 15 years ago that you've never touched and it's sitting in a dusty binder is not good enough. There's been changes to HIPAA. There's been a lot of different things that have been added to HIPAA. The advent of electronic medical records, so all the security issues that go along with that have been, proliferated over since the time of HIPAA's inception. So you absolutely need to have appropriate policies and procedures, and all your employees have to be trained on it. They have to understand any employee that's going to handle PHI as part of their job needs an initial training when they start their job and at least annual training on HIPAA. They should be signing off that they've done HIPAA training and understand. That's super important. You have to have a compliance and privacy officer. Same person will do, but you have to have someone who is engaged at the practice and noted as sort of the HIPAA person. You need to have reporting mechanisms for employees to report that they believe a HIPAA problem has occurred or a violation has occurred or a breach. So it can be, analyzed to see if there truly was a breach. And then you have to understand the reporting mechanism, how you report to patients, how you report to the Office of Civil Rights. That's the agency that's charged with HIPAA enforcement. I mean, those are the basic minimums. And any software you're using or needs to be HIPAA compliant. So you need to make sure when you're purchasing software or picking a vendor that they can attest to you that they are HIPAA compliant and show why they're HIPAA compliant. You need to make sure your email system is HIPAA compliant. You're only sending emails encrypted using encryption if you're sending HIPAA protected information back and forth. Those are really the basic things you need. It sounds like a lot, but once you have it all in place, it's just kind of will stay in place and will kind of roll from year to year, but you have to update. And Ericka's right. There's so many practices that when I say you have HIPAA policies and procedures, they don't. Or they look at me and say, well, I didn't think I needed them. It just, unfortunately, that's not a good enough excuse. You have to have it.
There's a lot of plans out there. They're not expensive. Some medical societies make them available. There's free training. A lot of hospitals offer it. But there's also, the practice can, make an online training. There's a lot of services where you can just pay one amount for the year and all your employees get training and then you get a certificate. So there's a lot of stuff out there right now that it's made it so much easier. But if you're I know a lot of practices are so overwhelmed and this is just another thing. But if you're thinking of selling, this is one of those big things that will create a lot of pause for a buyer because they don't want to take on this risk. And, Christina, one of the things we can also talk about is that, whether or not you're selling, there's a new trend where law firms are going after practices that they suspect may have not complied fully with HIPAA. So we have seen, some advertising by lawyers who are trying to do class action lawsuits, and they're looking for patients who are patients of particular practices. And a lot of this has to do with practices that do online marketing. And I don't want to get into a lot of detail. I think we'll maybe do a separate podcast about this, but maybe you just want to give a little bit of information about what the issue is.
Yeah, I mean, the concern that marketing is not being done properly, or they're using those sort of, they can, I think it's called meta analytics, or like Facebook uses, that tracks IP addresses of people that go to advertisements. There's been some discussion by the government somewhat recently that they don't love that. They think that's not HIPAA compliant. There was a court case that sort of said, no, we think it's okay. So it's a little bit in flux. But practices that heavily market on social media or try to gather patients that way and gather information that way, there are some law firms out there right now that are looking for class action lawsuits, thinking that's not appropriate, and are trying to gather data and information. So very important from a HIPAA perspective that you have sort of your ducks in a row. And we've seen, like Ericka indicated, we've seen practices get caught up in sales related to HIPAA issues. And even if it doesn't, let's say it doesn't derail the practice sale, and maybe it doesn't lower the purchase price, it will definitely slow everything up. So if you want to sell and you're looking at a closing date, let's say 60 days from when you sign your letter of intent, and they find a big HIPAA issue, you're not closing 60 days. It's going to push everything back. So, anything that you had in mind for wanting to have the purchase price by a certain time, or maybe a tax benefit if you did it by the end of the year, all that may be now going away because we have a HIPAA issue that slowed everything up for 30 days.
Right. Yeah, so one thing to take from this is that if you're doing marketing online, talk to your lawyer, make sure that what you're doing is being handled in the most appropriate manner, and that your patient information is not being collected, using data online. The second thing is patients should be signing authorization forms that allow you pretty generically and freely to use information for marketing purposes. If you're not having an authorization signed when patients are filling out their initial forms, or annually when they're completing updated documentation, include an authorization that allows you to use information for marketing purposes. And then finally, whatever these marketing companies are out there that are, make sure you have a BAA with them, at least cover yourself that way. So I think maybe we'll do a separate podcast on this with one of our partners that kind of specializes in this area, because I think it is going to become a huge HIPAA issue for many practices. All right, so a couple more things I just want to touch on very briefly. One of them has to do with whether your practice is properly calling somebody a contractor versus an employee. I know it seems very obvious. A lot of practices assume that if somebody's part-time, they can automatically be a contractor. That is but one factor in the test of whether somebody's a contractor versus employee. We have seen transactions derailed because the buyer's counsel believes that some of the people you're calling contractors should be employees. The government can go after practices, audit them, and there can be quite significant fees involved with misclassifying. So really important that this is something you're thinking about, and your accountant really should be guiding you on how to properly classify. Not all accountants are sophisticated in this area, so you can also talk with counsel as needed. So that's one thing I wanted to mention. The second thing, and I know Christina will agree, it comes up in every transaction, is that at least annually, semi-annually would be even better. Quarterly would be awesome. You should be running everybody who works for you, not just employees or providers, but administrative people as well, through the OIG database to make sure that they are not excluded individuals under under Medicare, Medicaid, or any other federal program. Every single buyer asks for this, and I have yet to come across a seller that does it. What about you?
Yeah, I think I can think of maybe one or two that I have that I think do it at least annually, but that's it. But I would say quarterly is the best way to do it. I mean, there are rules on that. If you have someone providing services that's excluded, or someone even acting as a manager, not even providing direct services, but they're excluded provider, they can't. So you need to be very, very careful about making sure that everybody's run through that database and that they're not going to show up as an excluded person.
Right. And by the way, you can lose your CMS number your provider number if you have somebody who's in that database working for you. So it's really in your best interest to check. I think everybody always thinks they know the people working for them and they wouldn't do that kind of thing. You
Yeah.
just know they could have just, embezzled money somewhere in their past and you don't know.
Yeah. You have no idea, really.
So that is such an easy one. You can just Google OIG database exclusion, and it's a free link. You can just search your people, assign it as a task to somebody working for you to do it monthly, quarterly, whatever. But there's really no excuse that you didn't get that done. That is an easy one, and it really makes you look good to a buyer, I think.
Yeah, exactly. And I think one other thing too that I just thought of that we've had some issue with, if you do any telehealth, if you're a practice that does a lot of telehealth, you need to make sure that you're registered in the states where you're providing services. That's usually generally required, and we've had that come up a few times on due diligence. Let's say you're a radiology practice and you're providing reads for patients that are sitting in 20 different states. You got to make sure the doctors providing those reads are all licensed in the states where the patients are sitting. And you also need to make sure, generally, with some exception, but generally, that you're registered to do business in those other states because you're providing services to residents of that state on a routine basis. And we've had some issues with that as well.
All right, boy, this could go on and on. We hope this has been helpful. And we'll do a follow up podcast at some point on some other issues that arise. But as we reach the end of the year, I know from talking with some clients that they're thinking 2025 is their year. They want to get ready. They're thinking of selling. And so I beg everybody listening to this to think about some of the issues we've talked about. Your EBITDA, your revenue is not the only factor in being able to sell. Before you spend money on legal fees, before you start negotiating with a buyer, spend a little time and effort and use your lawyer, use your accountant to make sure that your books, your compliance plans, etc., everything's in order. It will make it a less expensive transaction, potentially get you a better purchase price, avoid the necessity to be embarrassed that you complying with the most basic of regulatory issues, and will make your lawyer's job so much easier as well.
And lower your legal fees because every time the buyer's counsel sees something, they reach out to your lawyer, and then your lawyer reaches out to you, and you get billed for that. So the less that you have as an issue, the less you're going to pay in legal fees.
Exactly right. All right, so this has been the Health Law Hotspot. I'm Ericka Adler, and Christina Kuta has been on with me today. We hope you enjoyed this and that you find it helpful. And we will be happy to answer any questions you may have. We'll have our information posted when this podcast gets posted. And since we're recording this right before Thanksgiving, we wish everyone a wonderful Thanksgiving. We'll see you next time on the Health Law Hotspot.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.